we go. And Ms. Hill, do you need to be made a co-host? Does it matter? No, okay. I think we have everyone. Oh no, we're missing Dale. I think everyone's in now.
All right. Your Honor, before we get formally started, the city did want to bring up one kind of housekeeping matter, but we can wait till you're ready to get
Let me
going.
call the case and then we'll take it up on the record. Is the court reporter ready? Ms. Hill and the district clerks ready?
Yes, Judge.
Okay. All right. The court calls 2021 CVK 0000507D1 in the matter of Wolf Hoffman versus Laredo International Airport of the city of Laredo, Webb County, Texas. Can I have announcements of the attorneys for the parties, please?
Brian Henry for the city, Your Honor.
Joey Diaz for Jet Racing.
And Zone Win for Jet Racing.
Mr. Henry, what was the housekeeping issue?
Before we get started, Your Honor, Mr. Nguyen provided his appearance this morning. Normally, the city doesn't really have a problem if Mr. Nguyen is representing anyone that happens to be adverse to the city, even though I used to be a former assistant city attorney. That isn't usually an issue for the city, but in many of those, most of those instances, actually, he's not directly involved in like material aspects involved in the case. And the deeper we go into this one, the more we found he actually did have some direct personal involvement with some of the documents and everything that go to the merits of this. So I just need to kind of put on the record that we have an objection to his appearance on behalf of Jet Racing.
Do you have a response to Mr. Nguyen?
Yes, Judge. To be perfectly candid with the court and as well as the city, I used to work with them and I have fond feelings for them. I represented. I left the city in 2015. I did represent the city against Mr. Hoffman in a previous matter, and I believe I prevailed in that matter on behalf of the city. But that was not related to this. I believe it's related to previous concerns about his lease, and it was resolved. So that's why I believe that I do not have a conflict, because it was resolved, and I have no knowledge regarding that matter. It relates to the current matter, and it's been over 5 years or 6 years since I left the city.
Are you going to be primarily representing Mr. Wolf this morning at Jet Racing?
Well, this morning, yes. Or today, yes.
For today, yes, Judge. The rest of it, it's on lead, but the majority of the items with regard to the continuance and the initial stages is Mr. Nguyen is taking lead for today's hearings.
Okay. Well, without anything concrete as to whether or not he's had any specific dealings with this matter, I'm going to overrule the objection for today. If anything develops where the city feels that there's a conflict, they can raise it again.
Well, I can point to it, Your Honor. It's pretty direct. If you, off of what Mr. Nguyen did say, he was successful for the city in a prior suit, but what happened was there was a prior bankruptcy, and he drafted the settlement agreement that materially altered the conditions of the current lease. And so the current lease that is the dispute underlying all of this is that settlement changed it and is part of the lease right now. It's all consumed within one thing. And he had specific strategic discussions with city personnel regarding its creation and the negotiations and all the other stuff. So I agree with Mr. Nguyen that he did not have involvement with the current eviction matter, the current suit, but he drafted the documents upon which it was all based. So that's what the objection turns on.
Well, in reviewing the pleadings in this case, I think a lot of the issues are going to be resolved procedurally.
Mm-hmm. Okay.
And Mr. Nguyen, I'm going to overrule the objection, but the city is free to raise that again. And if you're comfortable that you're not violating your oath, then I'm going to allow you to proceed.
I am, Judge, and if I feel like otherwise, I would raise it. But like Mr. Henry says, I believe that I drafted the terms of that settlement previously, but thereafter, I had no involvement with either side regarding the enforcement or anything. So I drafted a document and I prevailed for the city, but that was, again, 6 years ago. So that's why I don't feel like I have any knowledge that would harm the city or compromise either party.
Okay, before I allow you to begin your presentation, Mr. Nguyen and Mr. Henry, let me tell you what I'm seeing from the pleadings and what concerns me. And that way, when you do your presentation, you might dedicate some time to my concerns. I was the judge that originally signed the TRO, and I will tell you that had there had not been any mention of the bankruptcy, there was a good chance I wouldn't have granted the TRO, mainly because we have an order that was signed by Judge Martinez, Hugo Martinez, back in November, basically ordering the eviction. Now, as far as I can tell from the pleadings, and that has become a final order. And some of the amended pleadings that were filed yesterday or today seem to be trying to relitigate something that has already been determined. And so that is the concern that I have today going forward. But I'll allow you to present your arguments today, but the court has concerns regarding issues that I think could be res judicata. It should have been brought earlier. And my other question is on the reference to the bankruptcy is that, and I just saw the exhibit Mr. Diaz sent me. I know initially when a bankruptcy is filed, there's the automatic stay that applies. If I'm reading the docket correctly, it wasn't a liquidation, it was a not reformation,
Reorganization. Right?
Reorganization, and the plan was in place. So
Yes, Your Honor.
the debtor in that case was back to functioning as a business that was no longer protected by the automatic stay. So I want to hear why you think bankruptcy would prevent the city from going forward with a valid order of eviction today. All right, so those are the concerns I have, and I'll allow you to proceed now. We have the rest of the afternoon, so I don't have anything else. Mr. Nguyen, it's your motion, and you're the petitioner, so the floor is yours. You may proceed.
Yes, Your Honor. And I believe that our case will be brief today. This is in no way trying to relitigate other matters. However, there's an attempt here to articulate what's really going on between Wolf Hoffman and the city. And that is primarily the 1983 action that the city is, under color of law, trying to deprive Mr. Hoffman of his constitutional rights to proceed with his ongoing business and contracting abilities. He's been at the airport since, I believe, 1994. So there's this long-standing relationship there as far as just wanting to continue. I'm not trying to get into previous leases and so forth. I'm just saying that he's been there. It was a lease for just flat property, and he's erected over $1 million worth of improvements there. So there is an irreparable harm in his ongoing business. I mean, there's only one airport. There's only one place he can conduct business in the city. This case is involved. It may take a year or so to litigate, notwithstanding the pandemic and all, but just getting the depositions in and so forth. But there is merit. It's going to take a while to formulate the prosecution of it. But if we do not have this preliminary injunction in place, then there is irreparable harm to Mr. Hoffman, because once he loses these clients, he can't get them back a year later and say, I was right. So there are no adequate legal remedies here to compensate him for that. He needs to maintain the status quo so he can conduct business. We believe there is a likelihood of success, as the pleadings show and have extensively stated. And there's no harm to the defendant because they will continue receiving the lease payments. the bankruptcy was in place as far as the activities, and the city was on notice. So that's why Mr. Hoffman believed that he should not have been drugged to JP court. He felt that he was just under duress, forced to sign the eviction agreement. And that's part of the case. That's part of the 1983 undue actions. So that's the case, Judge, in a nutshell. And we're asking for today to keep the injunction in place until the resolution of trial. Thank you.
Mr. Nguyen, assuming for the sake of argument, these 1983 claims would have existed prior to November 20th of last year. Am I correct in saying that?
Well, part of it, yes. I mean, I always want to be candid to the court, but then the activities since then have also led to the 1983. Actually, it's the main thrust of it, because now that's what's pushed them out the door. It's just the putting them behind the 8 ball, saying you got to get evicted. If you don't agree to this, you're going to get evicted sooner. So, I mean, he's just trying to cobble up his wares and get out, or now he's trying to see if he can stay in.
Let me ask you this. Was the city of Laredo listed as one of the debtors in the initial filings back in 2017?
I'm not sure if Mr. Tejas has that answer.
They were not listed as one of the original debtors, but the city filed, it's on document number 24. There was a notice of appearance and a request for notice filed by Cristina Flores on behalf of the City of Laredo Taxing Department.
And I'm
So-
assuming that was to lift the stay in order to proceed, though.
Well, that they were a party to the lawsuit. They entered their appearance into the bankruptcy proceedings. They received notice of all documents filed. The city had direct notice of the proceeding, and so the only thing regarding the issue regarding the bankruptcy isn't so much that they couldn't have gone forward with their eviction proceeding. They just needed to begin the proceeding through the bankruptcy part and then go after it from there, get permission from the court, because the stay doesn't get lifted until the plan is the bankruptcy is discharged and the plan is signed. The plan wasn't signed until February 4th of 2021.
Well, I saw that actually the plan was approved way before the eviction.
Well, it was approved in November. The original debtor's plan was approved in November of 2020.
And I'm not trying to be difficult here, but if Mr. Hoffman and Jet Racing was entitled to the state protection, wouldn't that have been a defense that could have been raised at any point after the JP case was filed and then got removed to county court at law number 1?
The county court at law number 1 overruled it, we believe, erroneously, but the plan, the original proceeding, the original eviction proceeding began in 2018, after the filing of the bankruptcy, before anything had been done. Then the new file, the new pleadings, the appeal in county court 2, I don't have the exact date.
No, bankruptcy was filed prior to that. According to this,
Yeah.
It was filed on the 2017 September.
Yes, I don't think there's any disagreement that the bankruptcy proceedings was initiated prior to any court proceeding in the eviction process.
And again, the thing that I'm grappling with here is how we get around the fact that we have a order that was signed by Judge Martinez that has become final, because the court's lost plenary power to amend that back in December of 2020. And you're asking this court then to ignore a proper ruling from another judge in Webb County. I don't know how to get around that.
Because that becomes the adverse action that is required for any sort of government taking. You can't have a government taking without an actual action being done. And so that final order is how the city is using and doing the taking. Like the threat of the government doing it to you isn't enough under 1983. You need to have the
And I don't disagree with that, except for the fact, as I asked earlier, that was a defense that could have been raised. That could have been raised earlier, and I don't see how res judicata doesn't attach to that and everything that could have happened prior to Judge Martinez signing that order of eviction.
because the actual proceeding itself isn't necessarily the taking, it's an attempt at it. And unfortunately,
The attempt was when they filed in JP court, I think. I mean, they were basically saying, get out, we're not going to let you do business here anymore. I mean, in a nutshell, I didn't see the actual pleadings, but your first amended petition talked about the eviction petition that was filed in JP court.
yes,
And it would have seemed incumbent about, and again, I know you all weren't representing him at that time, but one, that could have been raised as a defense. Two, if the renter was entitled to state protection, that should have been raised also at that time. And that's why I'm saying you're almost here trying to relitigate and raise defenses that should have been raised at the eviction hearing.
Judge, yes, if we had filed a suggestion of bankruptcy, that would put that court on notice. But our argument is that the city had noticed that he was in a bankruptcy proceeding and yet went through the JP court nonetheless.
Well, and again, just for the sake of argument, if in fact the city was in violation of a federal order of bankruptcy, wouldn't that be within the jurisdiction of the bankruptcy court to address and not the district court judge? All I know is that it wasn't raised prior to Judge Martinez signing an order of eviction.
But that act is related to the 1983 Act, whereas we go to bankruptcy court, we wouldn't have this action.
Well, I think what you're arguing is that it's a continuing kind of tort here, but what I'm saying is that the threat of taking started when they evicted him. And actually, and I'm assuming, and again, I don't know that the order was very clear, but I think they evicted him at JP level as well. So you already had a Texas court be a JP, but just as binding on the parties saying, we're going to take this lease away from you. Why wouldn't that be applicable at that time and not then and brought up now? And I don't take lightly the fact that we're talking about somebody's business here, but procedurally, I'm not seeing how we get around that order from Judge Martinez. And the circumstances may not have been ideal representing wise. I'm not sure what happened with the attorneys, but you know, I've worked with Judge Martinez before. The order started off with agreed. So I don't know how I get, and that was the first concern. And as I mentioned, when I read the TRO request, the only thing that kind of saved you was, in the sense that the only reason I mainly granted it was because, yes, there was harm going to be done, but I was curious as to whether or not the stay should have applied. And I'm not hearing or seeing anything that tells me that it did. So the plaintiff in this case, the city of Laredo, is within its rights to ask for eviction. Now, whether or not those grounds for eviction were just or not, again, those are issues that I have to assume and take judicial notice were taken up by Judge Martinez and not to be relitigated here.
And that validity of that order, and we're not putting it on Judge Martinez, it was addressed to him as an agreed order, but it was not what Mr. Hoffman would have agreed to, except for the pressure that was put on him.
Mr. Henry,
Yes, Your Honor.
you have a response to the overall lawsuit?
Yes, Your Honor. And you've actually zeroed in already on several key points of what I was going to be raising anyway. But to kind of start out with, one of the big issues with the city on why the eviction started was it wasn't about really rents or aspects like that. Because this is on the airport, the city had basically notices from the federal government that its grant funding and stuff was in jeopardy because of jet racing and it kind of in particular. And so the city looked at it as part of the its state action enforcement procedures as to why the state didn't apply when it started initiating things. But as Judge Martinez, he wanted to be very cautious and very conscientious of all of the matters. And so the city basically didn't do anything until, if you note on the docket sheet, jet racing and docket entry 131 filed its proposed order that says everything's closed out and done now because the plan had already been approved. And that was on November 2nd, I believe. Yeah.
Correct.
And so that was before Judge Martinez heard the actual eviction. So when they had the eviction, because the lawyer basically said, I filed everything, Jet Racing's bankruptcy attorney, he actually showed up at the hearing and they started going through it. And Judge Martinez was very cautious about making sure everyone told him on the record, yeah, the stay is not in effect. There's no reason we can't go forward. And they started a hearing and then they ended up agreeing on the record to the agreed judgment. So it became final in December, and its finality is it can't be changed. You're correct, Your Honor, that they're trying to relitigate the same issues. And what their injunctive relief is asking for is to stop the eviction. If they are bringing 1983 claims, if those are things that happened before, or if the city had violated the stay, because jet racing is a non-natural person, the proper mechanism is to bring it up to the bankruptcy court. They're the ones that enforce it. They do that through their contempt power, and none of that happened at the bankruptcy court. And the bankruptcy has since closed out, so it's a final order now too, which is actually docket entry 142. And the Texas Supreme Court not too long ago kind of examined an issue that I believe is very relevant or direct to it, because it's in the Engelman versus Shield Brothers case. And in that case, Your Honor, it was an argument between some landowners and an irrigation district, and they were fighting back and forth, and the irrigation district lost. And when the Shield Brothers tried to enforce the final judgment, the district basically said, well, the law clarified that we really would have had immunity from suit, so the judgment's invalid and we shouldn't have to follow it. You can't enforce it. And the Supreme Court took a very hard approach to that and said there are competing interests when you're talking about immunity from suit versus the finality of the judgment. But guess what? The finality of judgment controls. It controls all of it. It doesn't matter that you may have been entitled to immunity from suit. If that judgment becomes final, it's locked in and it can be enforced. And so what their injunctive relief, Your Honor, is asking you to basically take away Judge Martinez's ability to enforce his own judgment from his court. And all courts have the inherent power to enforce their own judgment. So I have more like legal arguments based on a judge, but you seem to already get the point that the proper mechanism isn't coming to district court to raise it. If there are, especially not for injunctive relief that stops the eviction. Now, the eviction aspect, that deals just with possession. It's cumulative. So other claims can be brought, but not claims that challenge the possession. And so as far as the injunctive relief they're requesting, there's actually no jurisdiction for you to be able to say anything as you pointed out, it became final. It's locked in. And so they really haven't raised anything that entitles them to injunctive relief at this point. While not exactly the same, there is a case where the Texas Supreme Court addressed a similar matter called McLaughlin versus Clyburn, which is at 672 Southwest 2nd, 231. And in that case, a landlord started an eviction proceeding, and the tenant filed suit in district court. But the distinction is the suit was still going on. The procedures were in process. And the Texas Supreme Court said, well, he can't establish a probability and likelihood of relief because he had a adequate remedial law, and that's to defend himself in the JP court and in the county court. That's his process. That's what the law allows. And so stopping it mid-process wasn't permitted. And here we've got a final judgment that's locked in that still you can't address. So, Your Honor, I think you keyed in to two of the principal legal weaknesses in what they're bringing forward and asking for this injunctive relief. So the city doesn't believe that it was that any injunction should proceed and that the TRO should be dissolved. And any of the other claims we can address later on, but none of them deal with stopping the eviction, which is what the point of today's hearing is.
Judge, if I may, continuing along this line, just so we can complete the logic, even if we proceed on with the eviction, there are considerable equipment and improvements on that land that require time to remove. It's difficult to be able to just, pack up everything from 26 years of business and leave within 5 days or 14 days, what have you. So it's not just one, to stop the eviction as we're requesting, but then two, to provide an orderly time to leave.
Your Honor,
Well,
may I respond?
yes, go ahead.
Well, the eviction was in November of 2020, and he's had 4 months. He's had plenty of time to pack up and leave. Once the eviction's executed, it kind of becomes the city's problem as to what's left in there.
I was going to, this judgment from Judge Martinez has been sitting there since November, Mr. Wynn, and I may sympathize with the predicament, but it has been 4 months since the ruling, going on 5, and really the filing of this petition really on the 12th hour. And I'm just curious whether at any rate, okay, I've heard enough, and I'm sorry, Mr. Wynn, but the court's ruling is going to be that the TRO is going to be dissolved. Injunctive relief is denied. And again, I think I've already kind of stated my reasonings, but this was a concern I had from the very beginning. And just to follow through on as you said, the logic is I don't know how I would be able to explain myself, though they don't ask me directly, to the Fourth Court of Appeals, why I ignored a sister court's ruling that has become final, clearly, and with no defects in notice or appearances or anything like that. And so I don't know how any court's going to get around that. But as Mr. Henry stated, I mean, all the other other causes of action will continue if you feel you need to go forward, but as far as the injunction, that's going to be denied.
We Judge, just real quickly, we understand that we're still able to proceed with all the lawsuits. We're here today just on the TRO itself.
That's correct. I mean, of course, not making any rulings on it.
The only part that we were just stressing on as far as the bankruptcy and why is just the way that the city went about it. They had notice. Once you begin a process incorrectly, even if the judgment's final, the judgment's void, and that was the presentation, the reasoning behind ours as far as why the proceeding itself, they needed to go in through the bankruptcy proceeding to ask permission to proceed with the bankruptcy, the eviction, and so that was it. But
well, just to address that clearly, I mean, I've heard nothing and seen anything that tells the court that you had the protection of the stay available to you at that time.
It stays, the bankruptcy law is fairly clear that it stays until the final order is signed off. We disagree with Mr. Henry saying that it ended in October. It's when the actual bankruptcy, it commences 30 days after the filing, and it commences until the bankruptcy is dissolved. And the bankruptcy did not become dissolved until February 4th of 2021.
But the other thing you have to contend with, Mr. Tejas, is that the city was not listed as a debtor in the bankruptcy case. And
but the problem is they availed themselves to it when they filed an entry of appearance and their notice of appearance, and they intervened.
well, the notice of appearance that they filed was for the purposes of, I'm assuming, property taxes, as it was the tax department, and that's part of the docket sheet.
I get that part, Judge, but just like the city of Laredo Airport is a subdivision, and Mr. Henry went out of his way to point out that they're all in one and the same, the tax department is the same thing. It's once one arm of the government of an entity, governmental entity has noticed, the whole government has in constructive notice.
Well, the court's made its ruling,
Sure.
Mr. Tejas, and again, I want to thank the parties for accommodating the kind of weird schedule for today.
May I
So-
prepare an order, Your Honor?
Yes, and I gave you my email if you want it.
Yes,
Sorry.
Your Honor, I have it.
Have you, go ahead, and I can't imagine it's going to be very complicated. So if you can send it to the court, I'll review it. And,
Yes, Your Honor.
okay. All right, thank you to everyone. Thank you,
Your Honor.
Michelle, for helping us out here today.
Yes,
Judge.
Yeah, okay.
Yeah, I think the only thing that's pending, we need a setting, if the court can direct to set us for a calendar call.
You should have been given one when you filed suit.
I don't believe so. I just remember getting the order for today's hearing, and so I think it would have been set as of today.
Judge, I do see a calendar call
Okay,
here in
there's one.
Odyssey. I
August,
have, yeah, it's for June the 1st.
Okay, that's
It's
fine.
Judge Lopez.
there you go.
All right,
you.
thank you.
thank you, Your Honor.
You have maybe excused.
Everyone's excused. Thank you very much again.
Thank you, Judge.
Thank you, Judge.
Thanks, Judge.